Good afternoon. My name is Alina Shevtsova. I am a discrimination attorney from Brooklyn, New York. In today's Legally Speaking seminar, I would like to talk to you about issues that may arise when you have a union at work, you're a member of the union, and at the same time you feel that the employer undertook some action against you that can be discriminatory, or you are plainly being discriminated at work because the employer created a hostile work environment. So what do you need to do in these situations? The problem here is that the union very often is the first entity to represent you and the first entity you would go to complain to. However, in most situations, unions are not going to address discrimination per se. They're going to be focused on collective bargaining agreement and if your rights under collective bargaining agreement were affected. And because of that, very often unions are missing from the grievance complaints and from the grievance procedures discrimination points. They do not bring them because they believe they can prevail on your issue without touching those points. For example, you were accused, you were written up. Your employer gave you a warning, and the warning was not deserved because amongst other points, because of discrimination. But your union did not raise this issue, and this issue very often will be waived. This is why it's very important to, number one, complain to union about all the reasons you believe you were wronged, including discriminatory reasons, and complain to them in writing. Number two, you will need to file a formal complaint of discrimination with your employer and with EEOC, or New York State Division of Human Rights. It's very, very important that you file those complaints to protect yourself. And finally, number three, when you deal with discrimination at work and you have a union, do not agree to settle your claims in the process of the grievance procedure if you are not fully satisfied and you believe that all of your issues were considered. Because very often what happens is that the union in the process of settlement negotiations with the employer comes to some sort of a conclusion, and it seems that all your, and it seems to you at least that you may proceed with discrimination part of your case, but very often later you would discover that you actually waived those claims when you signed the settlement. And it's very important to talk to a private attorney if you have such an opportunity before you sign any settlements when union is involved, if you also believe that you are being discriminated against. And you can read more about procedures and how to protect yourself from discrimination and what to do if you are a victim of discrimination on our website, forharassmentattorneys.com. Thank you.